supplementary list. This case item 4, first April 367 of 2018.
एक आइए
मेरा
आप लोग का क्या
मंडे को हम लोग एक सेट का लोग फाइल कर रहे हैं आफ्टर प्रॉपर्टी वेरिफिकेशन।
एक सेट का
मतलब द फर्स्ट इंटरलोकेटरी एप्लीकेशन व्हिच वाज अलाउड बाय दिस ऑनरेबल कोर्ट दोज पर्संस हु तो उसका हम मंडे को कर दे रहे हैं।
आपको मालूम है ना फर्स्ट इंटरलोकेटरी एप्लीकेशन पूरा बैच उसका आप लोग सबका वकालतनामा मिल गया।
हां
इट्स रेडी है
तो दैट कॉपी आल्सो आई हैव सेंट।
और बाकी लोगों
का माय लॉर्ड दे आफ्टर माय लॉर्ड।
देखिए ऐसा है ये मतलब आई एम नॉट प्रॉमिसिंग यू बट व्हाट वी आर डूइंग इज पूरा पार्टी पोजीशन हम लोग टाइप करना ठीक है जो जो सब्स्टिट्यूशन हुआ है उसको भी हम लोग टाइप करें। तो आपको एक ऐसे ही अनऑफिशियल ही रहेगा वो पार्टी पोजीशन तो क्या ही है वो आपको मिल जाएगा। तो अगर वी विल ट्राई ठीक है वैसे ये तो आपको दे ही लिया होगा सबका सॉफ्ट कॉपी
ये हम लोग को मिल गया है
सब मिल गया है।
हाँ, तो जैसे इसमें हमको इसलिए टाइम लगा
आप उनको सॉफ्ट कॉपी देते हैं हम लोग को नहीं देते हैं। हाँ हमारा टाइपिस्ट बैठ के टाइप करते रहेगा।
ठीक है
कब देंगे आप
मेल आईडी है कुछ
हाँ दीजिए दीजिए इनसे मेल आईडी लीजिए
अभी दे
हाँ आप एकदम फॉरवर्ड करिए जितना भी आपका सॉफ्ट कॉपी है ठीक है।
some difficulty we have faced लेकिन एक सेट अल्टीमेटली तैयार हो गया। we are taking some time only because of the reason कि एरर में कहीं मतलब रिकॉर्ड में कहीं एरर ना हो जाए। जैसे एक केस में मिला के देखें उसमें आया था that was with regard to 214 कि इसमें जब केस स्टेटस से मिला है तो that was something else। तब फिर हम लोग आके रिकॉर्ड देखे हाँ
अच्छा
ये बता रहे हैं ये किस में हुआ था
तो सही है हमारा ऑर्डर सही है।
हाँ मतलब उसमें एरर नहीं हो रहा है अभी तक फर्स्ट वाला सेट में
नहीं हम लोग बहुत ध्यान रखे हुए हैं क्योंकि नाम में एरर हो जाए ये सब एरर होने में दिक्कत है ठीक है।
तो
अब हम लोग का टीम बहुत ट्रेंड हो चुका है राइट
इस केस के लिए
ये सब चीज़ों के लिए बहुत ट्रेंड हो गए हैं
काम के लिए हमें करना है
ऐसा कुछ नहीं है आप कर लीजिए इसको। मैं आप हमको ये बताइए कि आप इसका हियरिंग कब से शुरू करेंगे।
हियरिंग बट आई एम ट्राइंग कि अक्टूबर का जो सेकंड वीक से खुल रहा है।
अक्टूबर पहुंच गया आप
नहीं बता देना क्यों कारण माय लॉर्ड विल सी अब तो 2 हफ्ता कोर्ट बचा है
हम तो सोच रहे थे कि महात्मा गांधी जी के जन्मदिन के दिन
हाँ ठीक है
उसके पहले ये जो है
नहीं उसके
जजमेंट होना चाहिए।
नहीं उसके बाद मिलेंगे क्योंकि उस छुट्टी में इसको पूरा पढ़ने को
अच्छा
ठीक है
आप हमको समझा रहे हैं
जब भी बोले
दुर्गा पूजा छुट्टी में आप पढ़ाई करेंगे।
नहीं हाँ है तो इसमें ये पिछला छुट्टी में 15 अगस्त वाला में था तो ये इंटरलोकेटरी बना है। अब ये वाला जो है तो सेकंड सेट ऑफ इंटरलोकेटरी के लिए है तो एटलीस्ट मतलब जिस दिन
एक और आज अलाउ कर रहे हैं
मान लो
अब हम लोग इसको आपका फाइल कर देंगे फर्स्ट सेट वाला
मंडे
मंडे
जैसे
को
फाइल करेंगे हम
तो हम ट्यूसडे को रख देते हैं
ट्यूसडे का टाइम लगेगा
उसको अलाउ करेंगे ना
हाँ
फर्स्ट सेट अलाउ करेंगे
फर्स्ट से पहला हम करेंगे
ये वकालतनामा फाइल करेंगे फिर उसके बाद जो है नेक्स्ट इंस्टॉलमेंट वाला जब आप बोलेंगे उससे कर देंगे।
तो हम मंडे को
FA number 209 of 2014 with ID number 11921 of 2025. This interlocutory application has been filed for substitution of deceased appellant number 2, 4 and 6. The details of legal heirs and successors have been mentioned in paragraph 2 of the interlocutory application. बाकी सेम ऑर्डर कर दें
सेम ऑर्डर
सेम ऑर्डर पंकज जी आपने सारा किया है, बिल्कुल सेम टू सेम करते हैं।
बस
ठीक है, आइए अलाउ।
कनेक्टेड टू
हाँ वो था एकदम एकदम सेम ऑर्डर, सबका सेम टू सेम किए हैं, इसीलिए हम उसको रिपीट करने में एरर हो जाएगा, इसीलिए हम रिपीट नहीं करते। योर ऑब्जेक्शन विल बी रिकॉर्डेड।
यस
हाँ, इनका ऑब्जेक्शन विल बी रिकॉर्डेड। जो
Second.
लास्ट सब्स्टिट्यूशन हुआ है उसमें इनका ऑब्जेक्शन
21
वकालतनामा फाइल किया ही हुए हैं और
26/8 वाला ऑर्डर
26/8 को रखें।
नहीं
26/8 को ऑर्डर
ऑर्डर लास्ट ऑर्डर
ऑर्डर
26
ठीक। इसमें आपका डिले है सब्स्टिट्यूशन के लिए 16 कितना डेज लिखे हैं, सबका तो अलग अलग होगा ना।
अलग अलग थोड़ा कॉमन मतलब वही है टीएस
All of them have expired during the pendency of this case. और इसको हम रख दे रहे हैं नेक्स्ट ट्यूसडे। कौन सा दिन है? At the request of the counsel for the appellant in first appeal number 367 of 2018, the matter is directed to be posted on 9th. He has submitted that certain substitution petitions, petition seeking substitution of some of the deceased respondents in first appeal number 367 of 2018 will be filed by Monday. ठीक है, ट्यूसडे को रखते हैं। आप भी अपने तैयारी कर रहे हैं?
कर रहे हैं
I will be requesting my lord.
सारा आप लोग थोड़ा थोड़ा अपना रिटन सबमिशंस बनाएंगे।
उसको वेडनेसडे रखते हैं क्योंकि मंडे को वो करेंगे और जैसे इनका ऑब्जेक्शन में फंस गया था तो उस ढंग का अगर कोई ऑब्जेक्शन हो कुछ ऑब्जेक्शन है
कुछ
इसलिए
objection
एक दिन
होगा।
का गैप करके बुधवार
अच्छा ठीक है, वेडनेसडे कर लीजिए 10 तारीख, ठीक है। सप्लीमेंट्री आप लोग अपना रिटन सबमिशंस बनाइए, ठीक है। हम लोग जो देखे हैं वो देखे हैं कि सेम काइंड ऑफ एविडेंस है सारे केसेस में, ठीक है। और क्लेमेंट ने हर एक क्लेमेंट ने अपना अपना एविडेंस दिया है, लेकिन एकदम स्टीरियोटाइप है सबका, कॉपी पेस्ट टाइप का लग रहा है देखने में, ताकि आप लोग देख लीजिए।
preparation of one interlocutory application and that took entire one day. इतना सारा रिकॉर्ड था, सारा को मैच करना।
हम तो आपको नहीं बताया कि हमारे स्टेनोग्राफर को 3 दिन लग गए सब इनकॉर्पोरेट करने में और 1 महीना लग गया सब पार्टी पोजीशन बनाने में। क्या समझ रहे हैं आप लोग? खाली आप ही काम कर रहे हैं। समर वेकेशन में भी इसमें काम हुआ है, पूरा समर वेकेशन वी हैव मॉनिटर्ड दिस।
कंफ्यूजन में फंसे कि जैसे झालो देवी हैं तो उनके नाम से वो 5 अपील में पड़ती, उसी तरह एक आया कि एक क्लेमेंट की
जी क्योंकि इतना कंफ्यूजन है और क्योंकि इतना कॉम्प्लिकेशन है, इसीलिए आप इस केस में हैं।
From supplementary list for hearing under order 41 rule 11 Act 403 second to 16 of 2017.
This is a plaintiff second appeal against the judgment of reversal. The plaintiff filed titles for declaration of his right title interest and confirmation of possession or in the alternative for recovery of possession. And if deed executed by defendant number 2 in favor of the defendant number 1 be declared null and void. The case of the plaintiff is that land of खाता number 28.
लिमिटेशन का क्या हुआ?
हाँ?
लिमिटेशन में क्या हुआ?
नहीं लिमिटेशन के बारे में नहीं कुछ है इसमें।
लिमिटेशन का कोई इशू नहीं है।
नहीं लिमिटेशन
ऐसे पूछ रहे हैं, हम नहीं देखे हैं।
नहीं लिमिटेशन में कोई इशू नहीं है।
तो विदिन टाइम ही फाइल हो गया।
हाँ विदिन टाइम, उसमें कोई लिमिटेशन करना है। The land of RS खाता number 28 dated by the district Lohardaga was recorded in the name of Sheikh Bodam and Bibi Medina lordship. And the case of the plaintiff is that there is no partition lordship. The case of the defendants is that the defendant number 2 is the dumb and deaf person, and he is incapable to understand or think lordship. Mechanically issue frame with the learned trial court lordship, para 10 lordship. Para 10, the relevant issue is 4 and 5. Whether the plaintiff has right title, interest and possession over the suit land described in Schedule A of the plaint, whether the deed of gift bearing number so and so dated 4/2/2003 with respect to suit land is illegal, null and void, not operative upon the plaintiff.
Who has executed this?
But defendant number 2, who is the deep person lordship,
Defendant number 2 has executed in favor of?
defendant number 1. And it is a joint family. There is a evidence that it is a joint family property.
Finding there.
Findings are suit has been decreed in my favor.
By saying what? There was no partition.
There is no partition lordship, and the defendants, their evidence admitted that there is no partition. It is a joint property lordship, and the defendant is not capable person to execute the
Capable
deed.
means he is mentally
Lordship, he is a dumb and deep person lordship. He is an illiterate person lordship.
Dumb, deaf, and illiterate person does not mean that he does not have senses.
There is so for the evidence of the defendant number 2, he stated that he does not know the khata number, plot number, lordship. I will show.
Statement dumb का evidence कैसे record?
By the expert of the defendant, the principal lordship. Lordship. The learned appellate court also reversed the judgment that it did not comply the section 12 of the Contract Act. Lordship, we kindly see the judgment.
Just let us see the finding of the trial
Yes.
court.
Trial court lordship, para 17 lordship. Para 17. The evidence of the defendant's loss. Page
नहीं, issue number 4 and 5
Four-
शुरू
four-
होता है para 16 से.
हाँ,
16 से पढ़िए.
60 support. That these issues are main and interrelated to each other so far as sake of the convenience they are taken up together in examination in chief. PW1, PW2, PW3 and PW4 stated before the court the suit land of RS khata number so and so. It is further stated then that before publication of RS Khatian, Chotan Mirdha and his wife died issueless. So Bodhan Mirdha, brother of Chotan Mirdha, became sole owner of the property of the RS Khata number 249-228. It has been further stated by them that after death of Bodhan, his two sons, Maru and Doman, inherited the property. It is further stated that Maru Mirdha died leaving behind his son, Chedia Mirdha, and 4 married daughters, namely so and so. It is further stated by them that Nishu died leaving behind his son, Naim. It is further stated that no partition took place between the Doman and Chedu Mirza regarding the suit property of RS Khata number 28 and 249. It is further stated that property of 249 is joint property of the plaintiff, Doman Mirza and Chedu Mirza, Jesu Khatun so and so. The plaintiff witnesses further stated that Chedu Mirza is a deaf and dumb person and is not capable of understanding things. So taking advantage of it is Naim Mirza took the Chedu Mirza to registry office and misleading him, both executed the deed in his favor without explaining the contents of the deed to Chedu Mirza. It is further stated since the Chedu is the deaf and dumb person, so he cannot understand the khata number, plot number, boundaries of the land. It is further stated by PW1 that he filed objection regarding the registered deed executed by Chedu Mirza before the sub-registry Lohardaga. Only the sub-registrar Lohardaga did not accept the objection. It is suggested him to go before the competent court. It has also been stated that PW1, PW2, PW4, PW4 that Naim Mirza after execution of the sale deed never came into possession of the suit land. It is further stated the plaintiff witness that Chedu Mirza is not born in the year 1948 when it is said that his mother got settled the land of Khata number 249 by Hukumnamna granted the land payment of rupees.
Just a moment. Defendant number 1 and 2 are part of the same family.
Yes. It is further find that PW 5 has proved 2 rent receipts which mark Exhibit 1 and Exhibit 2 respectively. PW 6 has proved the order dated 4/2/2003 of the District Sub Registrar Lodaga along with signature on the petition dated 4/2/12 filed on behalf of the Muhammad Siddiq Mirza, Taimuddin Mirza and Muzaffar Mirza, which is marked Exhibit 6 with objection. In cross-examination, PW2 admitted that he, along with his brother and father, sold some of the land of Khatam number 28. He further admitted he lives with his brother Maru Mirza separately but have joined cultivation. He also admitted that since Naeem Mirza got executed in his favor, misleading the Chedu Mirza, so he has filed the present case. PW2 also admitted that his father had sold about 3 acres of land. He further admitted that Chedu Mirza lived with his wife separately. He also admitted that his father, Doman Mirza, had instituted this case for 1 acre of land, Khata number 249, which is in Chester land, is recorded in Khatian of Samila jointly. He also admitted before the court that Chedu Mirza he never went before the registrar when they filed the objection petition before the registrar regarding the execution of the gift deed. Then registrar make endorsement to be moved before the competent court as the registered deed has already been executed. He also admitted that at the time of making the endorsement by the registrar regarding the advice to move before the competent court, he was present. The PW3 also admitted that Maru Mirza had one son, Chedu Mirza, and 4 daughters. However, he admitted that Chedu Mirza and Doman Mirza had separated living and cultivation. PW5 admitted that his receipt, which has been proved by him, is not issued in front of him. PW6 admitted the sub-registrar called the Chedu Mirza in front of him, but he cannot say whether any person was present before the registrar at the time of registration of the deed. He also admitted that there is no signature of typist over the exhibit sheet. DW1, DW2 in examination in chief stated the suit property relating to Khata number 20 is recorded jointly in the name of Chedu Mirza and Doman Mirza. I further find that including DW1, DW2, DW3, DW5, DW6 and DW7 also stated the partition have already been taken place long back between the Maru Mirza and Doman Mirza. They have separated living and cultivation. I further find that defendant is further stated in relation to suit property of Khata number 249, the mother of Chedu Mirza got settlement of 1 acre of land of RS Khata number 249 in the name of Chedu Mirza by A. Nama dated 16/12/1948 from the ex-land on payment of ₹65 and transferred the land. Since then, they are cultivating the land relating to RS Khata number 249. It is being further stated defendant witnesses suit property relating to RS Khatian 249 is a self-acquired property of Chedu Mirza and plaintiff have no right over it. I further find that defendant witnesses have also stated that Jelsu Khatin and so maternal auntie of Chedu Mirza, and Chedu Mirza is the real maternal uncle of Naeem Mirza. It is further stated that Naeem Mirza is a look after the manage the entire affairs of the Chedu Mirza. So out of love and affection, Chedu Mirza gifted the suit land to Naeem Mirza, also delivered the possession of the same. It is also stated defendant witnesses that Chedu Mirza is capable understanding the things also perform day-to-day affair. Now I find that Chedu Mirza alias Chedana Mirza is examined as defendant witness number 8. Since he is deaf and dumb person, so he was cross-examined through the expert who is the headmaster of the deaf and dumb government school. The expert stated before the court that witness Chedu Mirza is illiterate person, he cannot even write the name. The expert further stated before the court that witness Chedu Mirza by the gesture and symbol is stating that he has transferred the land to Naeem Mirza out of his own wish, as Naeem Mirza used to provide him food. He further find the expert.
You come to para 20.
Para 20.
These are the rulings they have relied upon, right?
Now I find that learned lawyer relied upon the following rulings mentioned in follow. In case of so and so, so and so.
So these are the judgments they are relied upon. Para 21.
No.
They also relied upon
yes,
Para 22.
I have considered all the documentary oral evidence available in the record. Also, ruling relied upon this. I find that present case the suit property involved relating to RS Khata number 28/249. Further find that it is case of the suit property relating to RS Khata number 249/20, the joint property of the Chedu Mirza, Doman Mirza. It is never partition between them. While it is a case of the defendant suit property relating to RS Khata number is a self-acquired property of Chedu Mirza. It is further case of the defendant the partition taken place between the Maru Mirza and Doman Mirza with regard to suit property of RS Khata 20. I find the defendant has produced and got executive now dated 16/12/1948 by by which it is said that mother of the Chedu Mirza got settlement of land 1 acre of property, Khata number 28 in the name of Chedu Mirza by its landlord on payment of Rupee 65. I further find that affidavit submitted on behalf of Chedu Mirza 2512, the age listed by Chedu Mirza 1 is about 75 years, meaning that Chedu Mirza is not even born 16 for 1948. I find that although Hukamnama is proved by the name Mirza, but certainly he was not present at the time of granting of the Hukamnama. I find that although deposed before the court that he is producing the said Hukamnama from the custody of the Chedu Mirza, it is came to the custody of Chedu Mirza from his mother Nijana Bibi, but to show that Chedu Mirza has admitted that he has received the said Hukamnama from his mother under such circumstances, genuine Hukamnama is not believable. I further find that in this case the rent receipt said to be issued by the Jamindar is not valid document creating title in favor of the Chedu Mirza. Moreover, I further find that RS Khata number 249 and apparent exhibit 4 and exhibit 4 shows that it is jointly recorded as a Bakas Madi under Khewat number so and so. Exhibit number 7 shows that land of Khata number 2/227 is joint land of the different person. I further find that new present Khatian of Khata number 120 which corresponds to RS Khata number 249. The exhibit 1 way shows that new survey Khatian is exclusively recorded in the name of Chedu Mirza, but it is established principle law the Khatian is not a document or a title unless revoked by the opposing evidence. Here in the present case, the defendant number 1 to fail to discharge their burden of Chedu Mirza acquired exclusively valid right title interest with regard to RS Khata number 249. So in this way, the land relating to Khata number is not are the self-acquired property of Chedu Mirza. I further find exhibit 1 by also show that there is only 81 decimal of land in new survey Khatian of Khata number 120. But the said Hukamnama shows that 1 acre of land settled in favor of the Chedu Mirza. In this which also Hukamnama is not said to be valid document. I further find that it has been admitted case of both the side of the Maru Mirza that had one son Chedu Mirza and 4 daughters. It has been case of the defendant relating to RS Khata 20. The partition took place between the Maru Mirza and Doman Mirza. And so Doman Mirza had sold the land of RS Khata number 28 by the defendant registered sale, which are marked exhibit B, BYK respectively. I find that defendant has not produced any document, brought any evidence on record by which it can be shown that the 4 sisters have sold any share of the land of RS Khata number 28, which may be shown that they have also accepted the partition between the Maru Mirza and Doman. From the original evidence, also find the Naim Mirza never came into exclusive possession of the suit land after the execution of the sale deed, meaning there a gift deed was not acted upon and property relating to Khata number 20 remained joint. I further find that
They are governed by which law?
Muslim law,
I don't know. You tell us.
Muslim law,
ये तो नाम से भी पता नहीं चल रहा है.
नहीं ये लोग governed by the Muslim law. Muslim.
In a case of registered gift, oral gift का तो कहानी है नहीं. In a case of registered gift, what are the preconditions?
It is first offer, second acceptance, and third delivery of possession.
ये कहाँ से बोल रहे हैं?
नहीं हम बता रहे हैं ingredients of
आप
the.
नहीं बता रहे. आप actually provision of law से बताइए. In a case of registered deed of gift, right? In a case of registered deed of gift, what are the basic ingredients?
Section 123, 122 or 123 of the transfer of property act.
That is it. Transfer.
122 laws. The gift is the transfer of certain existing movable or immovable property made voluntary without consideration by one person called the donor, called the donee, and accepted by on or behalf of the donee. The acceptance meant to be made. Such exception must be made during the lifetime of the donor while he is still capable of giving.
Okay. It can be. This acceptance can be at any point of time.
Lots.
Under the registered gift.
Yes.
So they say that there was no partition.
There is no partition lot. The defendant has not produced any document to show that there is a partition lot.
Even if there is a, let us assume that Chedi, what's his name?
Chedi Mirza, who is the defendant number 2.
Defendant number 2 was the same person. Let us assume for a moment, right? then a person can, even if he is a joint owner, he can transfer his share.
But there is no document which shows that how many lands lots is the share of the Chedu Mirda lots.
That's right, right. Though, so the what is the consequence? Whosoever is the purchaser or whosoever is the donee, he can seek a partition. He can seek a partition because the joint owner of a property is executing a deed. That deed does not become ipso facto invalid.
Law will say that the undivided share cannot be sold without the consent of the other co-sharer. नहीं मुल्ला लॉज में है, हम तो लाइन नहीं है, मुल्ला लॉज में है.
क्या मुल्ला लॉज?
मुल्ला लॉज का जो डॉक्यूमेंट्री है उसमें है कि विदाउट द कंसेंट ऑफ द co-sharer any part of land cannot be sold or gift or mortgage lots. But the learned the first appellate court lots findings lots mechanism थे. पेज 15
आप ये कहाँ से बता रहे हैं that they are governed by Muslim law? हमको तो
नहीं, इन लोगों को नाम से ही पता चल रहा है.
नाम से पता चल रहा है, ये सिर्फ कोई मतलब है क्या?
नाम से ही पता चल रहा है. सिद्दीक मियां, चेदी मियां.
उससे क्या मतलब है?
नहीं, it is governed by the.
No, we will not take it. We will not take it. नहीं, इनका पहला सेंटेंस रहता है governed by Hindu law, मृताक्षरा law, दया भागा law, Muslim law. ये तो ओपनिंग स्टेटमेंट रहता है प्लेन.
बिल्कुल रहता है.
Anyways, उसके बाद क्या हुआ?
उसके बाद
यहाँ पे there is a finding that he was not capable of understanding.
Yes.
In the trial court, where is that finding? ये तो operative portion में आ गया. Where is that finding that he was not capable of
Evidence shows
understanding?
that lots.
Evidence shows.
Page 15 lots. Page 15 the learned trial court lots में kindly see. May I read lots? Page 15, he further admitted that he had not seen any paper of the partition between the Maru Mirda and Doman Mirda. He further admitted rent receipt of suit land being issued jointly. He especially categorically admitted the khata number, plot number of the suit land was not explained to Chedi Mirda by gesture and sign. DW2, the Chedi Mirda is still cultivating the suit land, has not bought the suit land, mutated his name law.
Appellate court.
Appellate court. Page 15 lots. Page 15. There is a specific finding of the learned appellate court that the learned Munshi has found that defendant was not a competent person to execute the gift deed.
Page 15.
Page 15 lots of the learned first appellate court lots. The learned Munshi has found that defendant number 2 was not a competent person to execute the gift deed, being unable to state the khata plot number. The provision under section 12 of the contract was not examined by the learned trial court, and any finding for his capacity in examination before the court has not been given. The evidence for the plaintiff have been ignored. If the learned first appellate court law feel that the section 12 has not been ought to have been remanded to the learned trial court law. खुद बोल रहे कि section 12 of the contract was not examined by the learned trial court law. If there contract. What is the sound mind for the purpose of contracting? A person said to be sound mind for the purpose of making a contract if at the time when he make it, he is capable of understanding and for the forming a rational judgment as to its effect upon his interest. A person who is usually unsound mind but occasionally of the sound mind may make a contract when he is the sound mind. A person is usually sound mind but occasionally.
It is not your case that he was of unsound mind. Your case was he was deaf and dumb.
Yes, it is not the case of sound whether he is the sound mind or no unsound mind.
Case.
This is not the case. But there is a finding of the learned trial court that the appellate court that the learned trial court did not care the section 12 of the Contract Act law, which is perverse law.
ये तो shortcomings of the impugned judgment.
हाँ, short.
जो आप पढ़े हैं.
जी.
Finding दिखाइए ना. ये तो shortcoming of the impugned judgment से ये सब लिखा हुआ है. आप finding दिखाइए. Independent finding होगा ना first appellate court का. बट ये बताइए कहाँ
Para 5 lots of point for determination in appeal lots, page 6.
page 6
Lots of the learned first appellate court.
yes
Point for determination. The main question is to be decided in civil appeal being whether the right title interest of the plaintiff to be declared over the suit by cancellation of the deed lots.
finding
And the diligence.
इसे सारे एविडेंस को कंसीडर किया है ओरल एविडेंसेस को भी कंसीडर किया
जी.
ठीक है
There is no specific finding, Lordship. But page 11, Lordship, the shortcoming of the impugned judgment, Lordship. The shortcoming of the impugned judgment. Page 14, Lordship.
नहीं पेज 14 पैरा पेज 9 में आइए ना पहले पेज 9 में आइए
Page 9, there is a discussion of evidence, Lordship.
नहीं एविडेंस को ही तो डिस्कस किया है हाँ पढ़िए Defendant number 2 performs his routine work and he was engaged in agriculture also with the help of others. Right? Defendant number 2 used to visit nearby village market, purchase articles as per his requirement. Right? He used to visit barber shop and he identifies his land and house.
But
He was a married. He stated that defendant number 2 has married second wife, namely Sarkia Khatun, only 2 months ago. And in the marriage, Nikahnama was recited by him in presence of witness
But he
and
does-
secretary
but he
in
does not know-
cross-examination.
But he does. But
It is not a case of unsound mind.
Yes, I am not saying Lordship, but Lordship, he does not know whether he executing the deed of sale. He does not know khata number, plot number, Lordship.
There is also an evidence that the registrar called him,
Yes,
right? And what transpired between the registrar and him is not known.
but
But registrar had
the
called him.
plaintiff filed objection. The registrar said that you go to the competent civil court, Lordship.
कहाँ?
आया है कहीं पे एग्जाम अभी पढ़े
Para 15 में आएंगे.
para 15 of the trial court judgment.
Of the appellate court judgment.
The recapacity to execute, I have considered the question annexiously that whether the defendant number 2 was the competent person to execute the gift deed, a deaf and dumb person. It is to be mentioned that defendant number 2 has not been produced in the court and he has intelligently stated before the court regarding the execution of deed. I further find evidence brought on behalf of the plaintiff admitted that defendant number 2, though that being a deaf and dumb person, is capable to understand and capable of understanding and capable of forming the rational judgment as to its effect upon his interest. Section 12 of the contract, it is not relevant, Lordship. Section 12.
May not be relevant, but there is a finding that he was capable of understanding.
Lordship, he is not capable, Lordship. I will show the judgment of the trial court, Lordship.
No, there is a finding of the appellate court.
Which is a perverse, Lordship.
No, it's not perverse.
I will show the judgment of the
It
learned
is
trial
not
court, Lordship.
perverse.
Learned trial court judgment, Lordship.
The trial court has not come to a reasoning and then come
Para
to a
18, Lordship, you kindly see. It is a joint property, Lordship. It is a joint
इससे
property.
क्या होगा joint property?
Cannot sell joint property, Lordship.
दिखाइए ना cannot say joint property. It is not a case that they are governed by Muslim law. We do not know what law they are governed by. By merely looking at the name, we will not say that they are governed by
Yes,
Muslim law.
absolutely right.
Then-
But it is a joint property,
So what?
Lordship.
Even if it is a joint property, he is a co-owner of the property. It is not your case that he was not the owner of the property. Or
He
he
is
was
the
not the
owner of the
co-owner
property, but without the consent of the
Need not be there.
how can he execute the
Need
gift
not-
deed, Lordship?
ये तो सवाल का जवाब
Lordship, may I kindly say para 18, Lordship. Para 18 of the learned trial court judgment, Lordship. Thereafter, I will come to the evidence, Lordship.
कुछ नहीं आपके केस में.
Lordship, mainly this is very much important. Lordship, page 14, Lordship. एकदम middle line में. Further find that expert stated before in the court the witness Chedia Mirza is not capable of telling the khata number, plot number of land also.
I mean, merely because he is not able to tell the khata number, plot
But
number.
a person who executed the sale deed or gift deed, he must know that on which land lordship he is selling or gifting the land lordship.
You see, the expert further stated before the court that the witness Chedi Mirza, by gesture and symbol, is stating that he has transferred the land to Naeem Mirza out of his own wishes, as Naeem Mirza used to provide him food. Right?
प्लेंट में लिखा हुआ लॉर्डशिप, प्लेंट को कॉपी मिला है हमको. The plaintiff and defendant by faith Muslim, governed by Hanafi school. This is the plaint lordship. It is governed by the Muslim law lordship.
So, ठीक Muslim law. So,
but lordship, my submission
is there any law in Muslim law that undivided share cannot be gifted?
cannot be gifted without the
कहाँ
consent.
लिखा है ना भाई?
आज तुम जजमेंट लाए नहीं.
जजमेंट क्यों नहीं लेके आए? आधा घंटा से आपको सुन रहे हैं.
जजमेंट हम लाए नहीं लॉर्डशिप.
नहीं लाए हैं तो that's your problem. We do not know. Show me the judgment that under the Muslim law ये दीजिए जरा Mohammedan law दीजिए.
नहीं, हम मुल्ला लॉ को दिखाते हैं. मुल्ला लॉ
मुल्ला
में
ही दे देते हैं आपको.
हम मुल्ला तुम लाए नहीं ना.
तो
सबका अलग अलग एडिशन में अलग अलग लिखा हुआ है. सबका अलग अलग एडिशन में अलग अलग लिखा हुआ है.
Undivided portion नहीं कर सकते. You are not being able to show anything that undivided portion cannot be sold. They cannot be gifted.
So findings I have learned trial court का. I further find that it has been proved by the evidence that Chedua Mirza is not capable of telling the khata number, plot number, also contains the deed. So in this way, the deed of gift bearing number shown with respect to student land is not a valid document, Lord.
This is relating to khata number.
खाता नंबर 28, खाता नंबर 28 लॉर्ड्स। and 249.
Heard the learned counsel appearing on behalf of the applicant. This appeal has been filed against the judgment dated 29/9/2016, within bracket decree signed on 5/10/2016, passed by learned principal district judge Lohardaga.
Judgment I have you may I submit lords. 19 AIR 1992 3 पटना page 40 lords. A co-partner does not have a right to any.
Co-partner का कहाँ से कहानी है? मुस्लिम लोग बोल रहे हैं।
मुस्लिम लोग का है in the joint
तो co-partner का कहानी क्यों बोल रहे हैं आप?
co-partner का नहीं होगा।
अब तो बस co-partner का citation मत दीजिए। Passed by Principal District Judge Lohardaga, whereby civil appeal number 25 of 2012 has been allowed and the judgment of the trial court has been passed. The judgment of the trial court is dated 19/6/2012, within bracket decree signed on 29/6/2012, bracket close, passed by learned civil judge within bracket Junior Division, bracket close, number 4, Civil Court, Lohardaga, entitled suit number 6 of 2003. The suit was decreed and the learned First Appellate Court has reversed the judgment and decree. Consequently, the plaintiff is the appellant before this court. The suit was filed by the plaintiffs against the defendants, seeking declaration of right title interest and confirmation of the plaintiff, along with defendant number 2 to 5, with respect to the suit land of village Banda, PS Bhandra, PS number 230, district Lohardaga, bearing RS khata number 249, plot number 521, area 1 acre, corresponding to new survey khata number 120, new survey plot number 532, and RS khata number 28, plot number 1104, area 0.06 acre, corresponding to new survey khata number 119, new plot number 1176, and RS khata number 28, plot number 1101, area 2.5 decimal, corresponding to new khata number 150, new plot number 1173. An alternative relief was also prayed that if the plaintiff is not found in possession of the suit land, delivery of possession may be given to the plaintiff after ejecting the defendant number 1 from the suit land. A prayer was also made seeking a declaration that the registered deed of gift number 245/2003 dated 4/2/2003, executed by Khedi Mirdha within bracket defendant number 2 in favor of defendant number 1, in favor of Naeem Mirdha within bracket defendant number 1, be declared illegal, null and void, and not operative, and not binding upon the plaintiffs, and be cancelled. The specific case of the plaintiff was that the sued property was a joint family property, and under such circumstances, defendant number 2 was not a competent person to execute the deed of gift in favor of defendant number 1 without the consent of all the co-owners. It was also the case of the plaintiffs that defendant number 2 being a deaf and dumb person and the defendant number 1 by practicing fraud and misrepresentation got the deed executed, and the defendant number 2 was incompetent to execute the deed of gift of the joint family property, and there is no delivery of possession. It was further case that defendant number 2 was a person of weak mind and deaf and dumb person incapable of understanding anything well, was unaware to the fact that he was executing a gift deed in favor of defendant number 1. It was also the case that the contents of the gift deed was not explained to the defendant number 2, since defendant number 2 is an illiterate deaf and dumb person and is a person of weak mind, incapable of understanding a thing. It was further case of the plaintiff that the execution of the aforesaid gift deed was never admitted by defendant number 2 in presence of the registrar. That in what manner the content of the alleged deed of gift has been admitted, by and how he identified the khata, plot, area, boundary, etc., has not been explained by the registrar or the deed writer. It was also the case of the plaintiff that defendant number 2 is an illiterate, deaf and dumb person incapable to understand the thing well and is a man of unsound mind, not a competent person to execute the deed of transfer. Upon summons, a joint written statement was filed on behalf of defendant number 1 and 2, and another joint written statement was filed on behalf of defendant number 3 to 5. The suit was opposed by defendant number 1 and 2. It was asserted that though the defendant number 2 was no doubt deaf and dumb, but he had full capacity to understand the things by indicating and signed, and thus he was fully capable to choose and select right and wrong about himself and his property. it was also asserted that dependent number 2 was the only son of Maru Milka, and during the and while he was infant, Maru Milka died, leaving behind his widow Mohsama Niazan and a son, Chedu Milka. The mother of dependent number 2 took a Rayati settlement on 16/12/1948 from the ex-landlord, and on payment of salami, and the ex-landlord issued rent receipts in favor of dependent number 2. And consequently, ultimately, the dependent number 2 acquired a valid right title and interest over the suit property and enjoyed the same as the sole and exclusive owner of the property. It was his further case that after arresting, his mother was found in possession, and state of Bihar recognized dependent number 2 as Raiyat, and dependent number 2 paid rent to the state. The trial court framed the following issue for consideration. On behalf of both the sides, both documentary and oral evidences were reduced. The learned counsel for the appellant has submitted that issue number 4 and 5 are relevant for the purposes of this case. The issue number 4 and 5 has been decided by the learned trial court by paragraph 16 onwards. The learned trial court ultimately held that Chedu Milka did not acquire exclusive right title with respect to the suit property. And also held that the Hukumnama was not a valid document. The trial court also held that, observed that it was a case of the defendants that relating to RS Khata number 28, the partition had taken place between Maru Milka and Doman Milka. And so Doman Milka had sold the land of RS Khata number 28 by different registered treaty, which were marked exhibit B to B by 3 respectively. However, the court observed that no evidence was brought on record to show that the poor sisters had also sold any share of the land in RS Khata number 28, which could show that they had accepted the partition between Maru Milka and Doman Milka. The learned trial court ultimately held that Dependent number 1 never came in exclusive possession of the suit land after execution of the gift deed, meaning thereby the gift deed was not acted upon, and the property of Khata number 28 remained joint. The learned trial court further held that it was proved by evidence that Chedu Milka It was proved by evidence that Chedu Milka was not capable of telling the khata number and plot number of any land, and also the content of the deed. So in this way, deed of gift bearing number 245/2003 dated 4/2003 with respect to the suit land was not a valid document, and it could not be said that Chedu Milka transferred the suit land to Naeem Milka. And issue number 4 and 5 was decided in favor of the plaintiffs, and ultimately the suit was decreed. Before the first appellate court, the sole point for determination was the point for determination as claimed was as follows. The main question to be decided in the civil appeal being whether the right, title and interest of the plaintiff is to be declared over the suit land by cancelling the gift deed. The very first appellate court scrutinized the materials on record and the discussions of the oral evidences has been recorded in paragraph 11. The learned first appellate court specifically highlighted the cross-examination of DW3, wherein he stated that dependent number 2 performed his routine work and was engaged in agriculture, also with the help of others. He used to visit nearby village market, purchase article as per his requirement. He used to visit barber shop, and he identifies his land and house. And he has stated in this witness has also stated that dependent number 2 had married second wife, Lady Salika Khatun, only 2 months ago. And in the marriage, Nikhanama was recited by him in presence of witnesses and secretary, etc. He also stated that dependent number 2 used to look after his own land, and for last 20 years, dependent number 1 recited with dependent number 2. The court also highlighted that dependent number, the cross-examination of DW3, who stated that dependent number 2 is a deaf and dumb person, but he has got the capacity to understand and looks after his landed property at home. The learned court further recorded that recorded the provisions of Muslim law and referred to Rule 160. Dash give to Musa their property divisible. A gift of an undivided share with respect to Musa in property which is capable of division is irregular but not void. The gift being irregular and not void may be perfected and rendered valid by subsequent partition and delivery to the donee of the share given to him. And if the gift possession is once taken, the gift is valid. The learned code thereafter referred to the capacity to execute gift by paragraph 15 and held that the question that the court has considered the question whether the defendant number 2 was a competent person to execute a gift deed being a deaf and deaf person and noted that the defendant number 2 was produced in the court and he has intelligently stated before the court regarding execution of the deed. The court further found that the evidence brought on behalf of the plaintiff admitted that defendant number 2, though being deaf and dumb person, is capable of to understand and capable of understanding and capable of forming a rational judgment as to its effect upon his interest. The learned court further observed that the initial onus of proving unsoundness of mind is on the person who alleges it. For the normal presumption is that the person is of sound mind. The learned court thereafter highlighted the shortcomings of the judgment passed by the learned trial court and ultimately the appeal was allowed. And the judgment of the trial court was set aside. The learned counsel for the applicant, while assailing the judgment of the learned first appellate court, has submitted that the defendant number 2 was incapable of understanding the import of a gift deed inasmuch as he was not able to give the plot number, khata number of the property. He submits that this aspect of the matter has been considered by the learned trial court, but the appellate court has committed perversity by reversing the judgment of the learned trial court. He has also submitted that the property was a joint family property, and therefore a portion of it could not be gifted away. And on this account also, the gift was not valid. The learned counsel has also submitted that the possession of the gifted property was still not found with the defendant number 1, to whom the defendant number 2 had gifted. And therefore, the gift was illegal and void. And the suit was rightly defeated by the learned trial court. But the learned appellate court has not considered these aspects of the matter. After hearing the learned counsel for the applicant, this court finds that the learned first appellate court has meticulously scrutinized the materials on record to come to a finding that defendant number 2 was capable of defendant number 2 though was a deaf and dumb person, but I got the capacity to understand, has come to a definite finding by referring to the evidence based on record. And by highlighting the evidence of PwC, who had himself clearly stated that defendant number 2 though deaf and dumb person, but had got the capacity to understand and he looks after the language property. Other instances of his understanding has also been highlighted in the evidence of PwC. This court also finds that it was never the case of the plaintiff that this court also finds that the court has rightly held in paragraph 15 that defendant number 2 was capable of understanding, and the plaintiff who asserted that he was of unsound mind has failed to prove the same. The learned court has also considered that even undivided share could be gifted. And Rule 160 has been quoted and considered by the first appellate court. This court finds that the first appellate court has meticulously examined all the aspects of the matter with regard to the capacity of defendant number 2 to gift his property, though he was deaf and dumb, and also the competence to gift undivided share of the property. This court finds that no substantial question of law is involved in this case, according to the Supreme analysis.
Item 404, second appeal 242 of 2023.
Ms. Kapila?
Suit decreed and appeal dismissed. Basic claim was, my basic suit was that our case was that the plaintiffs, and undisputed case is that plaintiffs, the defendant number one's mother, in fact, she had married twice. From first husband, the plaintiffs were from the first husband, and the defendant is from the second husband. So the claim was The plaintiff's claim was, and the property, it was purchased in the name of, and it stood in the name of Jagni Kachap, who is the mother of both the from the first husband as well as the second husband.
Property in the name of Jagni Kachap.
Jagni Kachap.
Okay.
So obviously the plaintiff said that because the property stood in the name of their mother and therefore they had a right, the two sons were there and two daughters were there from the first husband.
They paid for partition.
Yes. Straightforward, the court allowed the partition, and our objection was that, Your Lordship, because the property had been purchased by the father of the defendant, that means from the second husband had purchased the property in the name of his wife, that means the mother of the parties, and therefore the defendant had exclusive right on the property. This was our claim.
Father had purchased. Benami.
Benami, yes.
कैसे चलेगा?
Benami,
कैसे चलेगा?
it was.
नहीं चलेगा ना? नहीं चलेगा.
This is our claim.
What happened before the learned court happened?
Both courts have ultimately allowed partition on the ground that because the property stood in the name of Jagni Kachap and therefore all the sons and daughters, yes.
That's right.
One more thing I must disclose, Your Lordship. Your Lordship, my basic plea on the first date was that because the plaintiff himself had said in his plaint itself that there were two other daughters also, two married daughters were there, but he had not included them as parties and therefore the suit was back for non-joinder of necessary
It was
parties.
held to be bad.
No, Your Lordship had directed us that the appellant's contention is that because he is denying the right of the the children from the first husband, therefore he did not make them a in here.
No, this plaintiff was seeking partition,
Yes,
right? So
Plaintiff.
why didn't he make the partition? If he is seeking partition,
yes,
he should have made everybody partition.
yes. That he has not.
That is not done.
No.
What is the finding on non-joinder?
Finding trial court says, Your Lordship may see the trial court.
Para number 9.
Yes,
Page number
page 19 of the trial court judgment.
Yes.
And it says, again relying on our community custom and therefore daughters do not have right and therefore their non-inclusion is not fatal to the issue. This is what it was said. But the appellate court does not say this.
Appellate court.
Appellate court does no such finding was there by the appellate court.
Where are the findings with, where is the finding on core issue?
Finding on
Core issue that the property belongs
to Jagni Kachap.
Yes.
Yes. Your Lordship would find it from the appellate court's judgment also and the trial court judgment.
Just show me that finding. Issue number 4. District purchased from our own funds.
Yes. And the actually the appellate court has made a general point for consideration that whether the trial court erred in decreeing the suit of the plaintiff.
Yes.
But the
trial court issue number 4 perhaps.
yes.
Issue number 4, right? Right.
Issue number 4 is the late.
Case concurrent finding.
Yes.
Second appeal number 242 of 2023 for the council pleading on behalf of the applicant. This appeal has been filed against the judgment dated 28th of July 2023, in bracket DP signed on 11th 2023, that is passed by the District Judge Roman 2 West Syndrome at Jaipasa. In civil appeal number 20 of 2020, affirming the judgment dated 10 July 2018, in bracket D2 signed on 23/7/2018, passed by the Civil Judge Senior Division 1 Jaipasa in original partition, suit number 22 of 2016. The counsel for the appeal has submitted that the plaintiffs and the defendant were children of one Jagni Kachap. However, the plaintiffs were through her first husband and the defendants were through her second husband. The learned counsel submits that since the suit property stood in the name of Jagni Kachap, the plaintiffs claimed partition he submits that the case of the defendant was that Jagni Kachap.
Your Lordship, my main contention is, Your Lordship, my record is in internal page 5, from last line it starts and
Of
next,
that appellate court.
appellate. Internal page 5, last line,
Yes.
this is my main contention, Your Lordship.
Last time.
It is submitted that with demise of Basuram, Jagni Kacha left matrimonial house of the first husband, leaving her children. Yes.
Internal page 5 of the appellate court judgment. Civil appeal. The bottom में है ना page number.
अब
Bottom में page number.
जी
Para number 4 है.
हाँ जी
कहाँ से पढ़े?
हाँ पैरा नंबर 4 का लास्ट लाइन जो है, इट इज सबमिटेड दैट वासुराम, he was the first husband, Jagni Kachap left the matrimonial house of her first husband, leaving children from first marriage under the care and guardianship of her in-laws, and she married Ignace Kachap, who was having a railway service, and denied that Jagni Kachap was residing with her children from first marriage under one roof. The plaintiff never resided with their mother during her lifetime. They used to reside at Utka at their father's house. That with regard to statement so and so submitted that Jagni Kachap was simple housewife having no source of her own income. The acquisition of suit property was made in the name of
This one should be sufficient last one.
this is yes.
The counsel for the appellant has submitted that the specific case of the defendants was Jagni Kachap left the matrimonial house of her first husband, leaving her children from first marriage under the care and guardianship of her in-laws, and she married Ignace Kashyap, who was having a railway service. And it was asserted that the plaintiffs never resided with their mother during her lifetime. It was also asserted that Jagni Kachap was a simple housewife having no source of income. The acquisition of property was made in the name of Jagni Kachap as a wife of Ignace Kachap and by Ignace Kachap out of his own source of income. The learned counsel has submitted that even if the property stood in the name of Jagni Kachap, but the same was purchased by Ignace Kachap in her name, who was her second husband, and consequently the plaintiffs being children to first husband, had no right to seek partition with respect to the suit property.
Yes.
This means that this aspect of the matter has not been properly considered by both the courts, and accordingly a substantial question of law be framed and be decided by this court. After hearing the learned counsel for the appellant, this court finds that it is not in dispute that the plaintiffs were from the were children to the first husband of Jalnikatcha, and dependents were children to the second husband of Jalnikatcha. And plaintiffs had filed a suit seeking partition of property which stood in the name of Jalnikatcha. And further, the defendant contested the suit on the ground that the property was purchased by second husband in the name of Jalnikatcha, and therefore the suit property could not be partitioned between the plaintiffs and the defendants. The learned trial court framed the following issues for consideration. The core issue involved in this case is issue number 4, as to whether Jalnikatcha purchased the suit property out of her own fund. This court finds that the learned trial court has considered all the materials on record while deciding issue number 4 by paragraph 5, and has come to a finding that the suit property was purchased by Jalnikatcha from her own fund, and decided the issue in favor of the plaintiffs, and ultimately directed for partition of the suit property. So far as the learned first appellate court is concerned, the sole point for determination, the sole point framed was whether the trial court erred in decreeing the suit of the plaintiffs. The learned first appellate court.
This finding is there in internal page 14, para 18, just before para 18.
The learned
Having
first
gone
appellate
through,
court has given a finding that the trial court has rightly decided the issue in favor of the plaintiff by holding that the suit land was purchased by Jalnikatcha, and as such it was a self-acquired property. The finding was arrived at after considering the materials on record. This court finds that both the learned courts have scrutinized the materials on record to come to the finding that Jalnikatcha had purchased the property from her own fund. No perversity in the matter of appreciation of evidence as such has been pointed out by the learned counsel for the appellant. And once the property was held to be the self-acquired property of Jalnikatcha, the learned courts have not committed any error in partitioning the same between plaintiffs and defendants. Accordingly, there being no substantial question of law involved in this case, this appeal is dismissed.
From date is court hearing and order 41/11 Act 30, Second 2503 of 2017.
This for the appellant. Yes.
Not concurrent finding against plaintiff.
Okay.
Plaintiff has filed the suit for declaration of right taking interest over certain plots on the basis of Hukumnama. Hukumnama has not been filed.
Not executed.
Filed you
For For the learned counsel appearing on behalf of the applicant, this is SN number 508/2017. This appeal has been filed against the judgment dated 11/8/2017. In fact, DT signed on 24/8/2017, passed by the District and Additional Sessions Judge Government 12 Rariban, entitled appeal number 47 of 2012, whereby the appeal preferred on behalf of the appellants has been dismissed, and the judgment dated 6/7/2012, within bracket DT signed on 18/7/2012, passed by the civil judge within bracket senior division bracket rules Roman Court Rariban, in bracket suit number 132 of 2001, has been affirmed. The suit was dismissed and the judgment of the trial court was upheld, and consequently the plaintiff is the appellant. The learned counsel for the appellant, the learned senior counsel for the appellant has submitted that the learned courts have committed error of law by dismissing the suit and have not properly considered the materials on record, and therefore a substantial question of law be framed and appeal be admitted and decided. After hearing the learned counsel for the appellant, this court finds that the suit was filed by the plaintiff seeking a declaration of title and confirmation of possession over the suit land of plot numbers 1362, 1363 and 1364 pertaining to khata number 195 for a total area of 8.10 acres situated in village Kanchanpur, PS Kathsandi, Hazaribagh, described in Schedule A of the plain. They also sought recovery of possession if found dispossessed and a suit and a decree for permanent detention. The specific case of the plaintiff was that the property was Gad Mabiba Khas under Khewat number 26 and was recorded as Salimat Malikan. Out of which Khewat number 4/1 was recorded in the name of Milan Minto. And Namu Minto. 8 by क्या हुआ? 8 आनास.
8 आना
हाँ, 8 आनास.
नहीं 8 पाई मैंने 1 रुपया का 16 आना का 1 रुपया
हाँ.
और
8 by each.
8 पाई अलग है लोअर डिनोमिनेशन
8 pi.
8 पाई
Both having equal share.
आना रहता तो थोड़ा मेजर शेयर होता
And Khewat number 4/2 was in the name of Shohan Metro, 1 Anna in Cadastral Survey Khatna. It was further case of the plaintiff that Peter and Shohan were co-sharer landlords. Settled the suit land by way of Hukumnama on 15 Vesak Samvat 1983 Sal in favor of Lucky Mehto, son of Sodi Mehto, and Lalu Mehto, son of Bodhi Mehto. The settlers were already in possession with prior permission of the landlord and reclaimed the land and paid rent to the ex-landlord. It was also their case that they have forfeited the title by year at first possession. It was further It was further the case that upon vesting under the Bihar Land Reforms Act, the settlement were recognized as tenant and legacies were granted in their name. The plaintiff asserted that
एक आना में 12 पाई होता है और ये 8 पाई के हिस्सेदार।
the plaintiffs ultimately claimed property on the basis of their possession and also claimed adverse possession. The defendants contested the suit. And asserted that their father and mother got the land by virtue of Hukumnama in the years Samvat 1984 and 1995, and since then they are in possession of the property. And the settlement was made by the ex-landlord of the village. The defendants denied the arraignment of the plaintiff and contended that defendant number 1 and 2 took settlement of lot number 1360, 1360, 1364 in 1984, 1995 Samvat from the rightful owner, and the rightful owner was Nanu Mento, who had right title and interest and possession over khata number 195. They also asserted that the demand was open in their name and they were paying rent to the state. The title brings the following issues for consideration. Issue number 5 and 6 were the main issue which were considered by the Lalit High Court by paragraph 5 onwards. The Lalit High Court considered all the documentary and moral evidences of the parties
एक बेदखली केस हुआ रामेश्वर को वर्सेस मोहन किया है in which रामेश्वर was pretty point. ये ट्रायल कोर्ट का इंटरनल पे 12 पैराटेक का मिडिल 144, 145 के बाद देखा जाएगा and Viruti certified copy of the Dusty case number second that
the High Court considered the materials including the certified copy of Vedati case number 1 of 2001-02 and other related documents and held that the dependent was in possession of the suit property.
They have filed hukumnama, but plaintiff has not.
The learned court also recorded that the defendants had also filed hukumnama and other documents in support of their case, but the plaintiff had not filed the hukumnama, which was the base document on the day. Hukumnama on the basis of which they claimed right title interest over the suit property. This court finds that the learned trial court, after considering all the materials on record, came to the conclusion that the defendants and sisters were the actual secretaries of the suit land, and they were having occupancy right over the suit land since the days of settlement, and held that the plaintiff has hopelessly failed to establish their title and possession of over the suit land, and held that the plaintiff was not the settler of the suit land at any point of time, and they had no possession, no title and possession with respect to the suit land. This court finds that the learned first appellate court has also considered the materials on record and considered the same issues as that framed by the learned trial court. Same issue considered है?
One permanent वाला ABC कर.
हाँ, ये क्या same है कि अलग?
That was
नहीं. The following points पर determination इसको translate करना होगा. Para 15 में.
yes.
ठीक है. The learned first appellate court considered the issue number, the point of determination number B and C together, and came to concurrent findings and decided the same against the plaintiffs. This court finds that both the learned courts have scrutinized the materials on record and came to a definite finding that the defendants have been able to prove their right title, interest and possession with respect to the suit property, and the plaintiffs had miserably failed to prove their right title, interest and possession. Both the courts having considered the materials on record, no perversity in the matter of appreciation of evidence by both the courts as such has been pointed out by the legal counsel for the applicant. This court is of the view that no substantial question of law is involved in this case, which is hereby dismissed.
From supplementary list order will be item 3, first April file number 5636 of 2025.
स्टेट का वैसा तो कुछ काउंटर में नहीं आया. Not say that
We have filed a supplementary reply on 29 and 20. As per our contention, Lordship, as per code fee section 19, there are some instances where code fee, some document against which code fee may be exempted, Lordship. But
Executive level का claim नहीं है.
They are
They are not
seeking
claiming, no. Are you seeking exemption?
No,
the
no.
court.
They are not seeking exemption.
But should we have a judgment on that point?
On exemption. They are not seeking exemption.
Yes, sir.
Exemption का कहानी कहाँ से आया? कहाँ से आया ये? जो भी मिलता है उसको लेके फाइल कर देते हैं। आपका रिप्लाई है exemption का कौन सा कहानी डाल है इसमें?
नहीं, फाइल किया उसी के लिए।
Exemption का exemption नहीं मांगे हैं। They say that advalorem court case is not payable because it's an award. एक लाइन का बात यही है इनका। बताइए।
ये तो
जितना भी लैंड एक्विजिशन मैटर्स होता है, राइट? ये आप बताइए एग्जेम्पशन का कहाँ से लेकर?
कम्युनिकेशन गैप हो गया।
क्या कम्युनिकेशन गैप हो जाएगा भाई इसमें?
लीगल क्वेश्चन है। We need to assist.
लैंड एक्विजिशन ऑफिसर दिस हो जाए तब तो भगवान ही बचा सकता हम लोग।
पहले ऑफिसर्स
एग्जेम्पशन का केस नहीं है।
नहीं, बहुत ज़्यादा एक मतलब तमिलनाडु आंध्र प्रदेश का जजमेंट मिला। देयर आर सम व्यूज ऑफ अदर हाई कोर्ट्स आल्सो, बट हमको लगता है कि प्रोनाउंसमेंट जरूरी है। इसलिए मतलब मेरे माइंड में दो बातें चल रही हैं। 3G में वार्ड बन गया, NH एक्ट 3G में वार्ड बन गया। आफ्टर ए वार्ड इज ऑलरेडी मतलब प्रोनाउंस्ड, देन कम्स द क्वेश्चन ऑफ डिस्ट्रीब्यूशन ऑफ द मनी और एक्सेट्रा एक्सेट्रा। हम फैक्चुअल आस्पेक्ट नहीं, 3H में जमा हुआ पैसा 3H1 में, उसके बाद अपोर्शनमेंट का बात आएगा तो देयर शैल बी रेफरेंस। जैसे ही रेफरेंस हुआ तो मतलब 3H का रेफरेंस है। अब ओरिजिनल साइड में कोर्ट सुनेगी, ओरिजिनल साइड में जैसे ही कोर्ट सुनेगी तो उसका अपील सेक्शन 96 में CPC में यहाँ आया। वेदर मतलब it is a declaratory decree given by the civil court. If it is declaratory, then I am ready to pay. I have paid 1,000. ad valorem पेमेंट होगा तो भी कहता है प्रोविजन सेक्शन 8 का कि अगर डिफरेंस ऑफ क्लेम आ रहा है तो डिफरेंस अमाउंट का ad valorem कोर्ट भी देंगे। अदरवाइज बोलता है प्रोविजन, ये शेड्यूल 1 और 2 जो है वो शेड्यूल 1 कहता है ओरिजिनल कोर्ट के सामने में हमको देना है ad valorem कोर्ट फी, और आइटम 13 जो है उसमें 1000 है। अवार्ड के अगेंस्ट में भी जो अवार्ड दे दिए हैं, पेज अगर देखेंगे ये सिविल कोर्ट भी तो मतलब वो अवार्ड पास कर दिया।
आप कौन से एंट्री में नोटिस पाएंगे? क्या मिनट्स का कॉपी ऑफ द नोटिफिकेशन?
हाँ, हम एंट्री 13 में की।
एंट्री 13 में बहुत सारा सब आइटम है। कौन सा?
एंट्री 13 में मतलब रोमन 4 टू सेट असाइड एन अवार्ड 1000 है, उसके जस्ट अबव वाला देखा जाए कहता है टू ऑब्टेन ए डिक्लेरेटरी डिक्री वेयर नो कॉन्सिक्वेंसेस डिफीट।
तो हम लोग का यहाँ पे जितना भी लैंड एक्विजिशन का प्रोसीडिंग से आता है, लैंड एक्विजिशन एक्ट से
उस
सब में अवार्ड होता है।
था लेकिन क्या होता
सब में ad valorem
हम बताते हैं उसमें क्यों होता है। सेक्शन देखिए लैंड एक्विजिशन एक्ट में रेफरेंस होता है सेक्शन 18 का, इसलिए कि अवार्ड के स्टेज में ही रेफरेंस चला जा रहा है, वहाँ अवार्ड डिलीवर नहीं हो रहा, अवार्ड प्रिपेयर नहीं हो रहा। वहाँ पे क्या हो रहा है, यहाँ पे 3G में अवार्ड बन गया, इट अटेन्स फाइनलिटी, अवार्ड बन गया। अब 3H1 बोलता है कि जमा होगा पैसा वहाँ पे, हमारा फैक्ट अदरवाइज है, उस बात पे बाद में आएंगे। लेकिन
3H में सिर्फ डिक्लेरेशन के लिए मैटर जा रहा है, वहां सेक्शन 18 में अपील है और सेक्शन 54 में फर्दर अपील है।
यहाँ पे आपने किस प्रोविजन में अप्लाई किया?
हम लोग सेक्शन 96 में जो कि जनरल सीपीसी में चलेगा, क्योंकि हमारा वहाँ सिविल कोर्ट से आ रहा है तो करें। और एडवोकेट कोर्ट फी इसलिए नहीं लगता, हम दे जानते हैं कि यहाँ बाकी सब देते हैं, दिया जाता है, ये चला आ रहा है प्रथा।
सेक्शन 96 में जब आप फाइल कर रहे हैं तब तो आपका एडवोकेट को देना पड़ेगा ना। अगर कोई स्पेशल प्रोविजन है टू फाइल एन अपील बिफोर दिस कोर्ट, यू आर फाइलिंग अंडर सेक्शन, यू सी नॉर्मली इस पर एक बार बात हुई थी, आपने समझाया।
सेक्शन 13 एक बार देखिए ना, आइटम 13 एक बार देखिए,
एनएच एक्ट
एक बार नहीं, यही शेड्यूल देखिए।
हाँ एनएच एक्ट है, एनएच एक्ट से कवर्ड
नहीं नहीं,
कौन सा एक्ट?
ये वाला हम बोल रहे हैं,
ये तो कोर्ट की एक्ट है और
एनएच एक्ट से कवर्ड, राइट।
are you seeking a prayer to set aside an award?
नो
No.
नो,
तो फिर इस set aside an award का क्या है किया?
इसलिए कि जो कोर्ट जो है सिविल कोर्ट, वो अवार्ड के ऊपर एक अनदर अवार्ड कर दिया इन अपील, सेक्शन 96 में मिसलेनियस अपील टाइप का।
See,
यस,
your belief before the trial court
वायलेंस,
was not to set aside an award.
नो ऑब्वियसली नो,
Not.
वो तो दूसरे के आपत्ति पे गया था।
So therefore, ये जो आप to set aside an award का जो आप उसमें prayer कर दिए हैं,
इसलिए किया है वो सेकेंड अवार्ड दे दिए, तो भी वहीं पे भी क्लियरिटी नहीं। पेज नंबर बताइए, बैलेंस देखा जाए।
as well as court fees कहाँ provision?
हम देखा था कोर्ट फीस एक्ट में,
हाँ
अभी देखें एक चीज खाली देखा, सप्लीमेंट्री में लगा
कहाँ पे provision?
ये मेरे सप्लीमेंट्री में, मतलब आइए जो हम लिखे हैं इग्नोरिंग डिफेक्ट, उसका पेज 14 एक बार देख लीजिए, उसका पूरा फिगर मिलता है। पेज 14 ऑफ माई, मतलब आइए नंबर
वो तो award है ना?
ये क्या किए हैं कि लैंड एक्विजिशन प्रिंसिपल डिस्ट्रिक्ट जज दूसरा अवार्ड पास कर दिया। अब देखा जाए नीचे टॉप में देखिए अवार्ड नया, कैन यू डू इट?
That is on merit. We do not-
मतलब देयरफॉर हम कर रहे
किसको
हैं,
आपको देना है?
सो दिस इज एन अवार्ड,
अभी तो कोर्ट फीस की बात करेंगे। This is an
अवार्ड
reference made by, आप उसको अवार्ड छोड़िए, reference made by the competent
Officer
officer
of
of
District Land Acquisition
under section 3H4,
H4,
right?
यस,
तो बस हम लोग यही देखेंगे ना,
हम
3H4 में क्या है?
इतने पे देखेंगे। 3H4 दिखाइए, उससे पहले 3G दिखाइए। Where is your 3G? Very lordship.
3H4 में क्या है?
3H4,
हाँ,
3H4.
this award has been determined under section 3H4. दिखाई तो हुआ है।
Kindly have 3G, उससे पहले
नहीं आप पहले तो अवार्ड का ही
ये लिख दिए ना 3H,
reference made by the
3H.
competent officer, District Land Acquisition Officer Bokaro under section 3H4 of National Highway Act.
Right.
Right? So reference was made under section 3H4.
अब देखा जाए इसको 3H में क्या है?
पहले 3H4 पढ़ी?
3H हम पहले पढ़ना शुरू कर रहे हैं. 3H deposit and payment of amount. The amount determined under 3G shall be deposited by central government in such manner as may be laid down by rules made in this behalf by that government with the competent authority before taking possession of the land. Now I am skipping 4 में. If any dispute arises as to apportionment of the amount or any part thereof or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal district court. Original jurisdiction within the limits of whose jurisdiction the land is situated. So वहाँ सिर्फ डिक्लेरेशन हो रहा है. 3H4 में सिर्फ डिक्लेरेशन हो रहा है. अमाउंट तो डिटरमिन्ड है पहले से. और मेरिट पे हम आएंगे कि उस पर कोई किसी का ऑब्जेक्शन मतलब टिल
डिटरमाइन हो रहा है इन द सेंस एज टू बिटवीन co-claimants.
Declaration, determination. Yes.
Between co-claimants or by third party.
Absolutely.
Alright, this is the claim by third party.
हाँ, third party. Who never opposed.
Who was not a party to the award.
हाँ.
Original award.
Not even an objector.
Maybe not an objector.
But he was not a party to the award. He raises objection later on. Yes.
Third party.
It can be third party. Yes. Sure.
So his right, title, interest, everything will be decided in this.
Yes.
With respect to the suit land. Unless his right, title, interest is decided, no amount of compensation can be
Now
claimed by him.
therefore come to the Court Fees Act. Now let us treat it to be an award also. Let us come to the Court Fees Act.
ये वाला लें 2025
ये वाला यहाँ वाला झारखंड वाला लीजिएगा तो
झारखंड वाले। आप इसमें से मतलब यू आर रिलाइंग अपॉन 13 रोमन 3 और 13 रोमन 4 दोनों में से कौन एक पे रिलाई करेंगे ना. आपने कितना नोटिस दिया है 500 और 1000 तो इसका मतलब यू आर सीकिंग दोनों में 1000 है. दोनों में से आप किस पे रिलाई करेंगे.
मतलब हम रिलाई करेंगे अगर इसको डिक्लेरेटरी मानेंगे
डिक्लेरेटरी मानेंगे. आपका तो राइट टाइटल इंटरेस्ट सब कुछ डिसाइड होगा इसमें बिकॉज़ यू आर अ थर्ड पार्टी.
नहीं हम थर्ड पार्टी नहीं है. मेरे फेवर का अवार्ड है. मेरे फेवर का अवार्ड है. थर्ड पार्टी है प्राइवेट रिस्पोंडेंट. यहाँ पे
ठीक है. प्राइवेट रिस्पोंडेंट है फाइल अ केस राइट. क्लेमिंग ऑब्जेक्शन और क्लेमिंग और जिसकी वजह से ये रेफरेंस हुआ
इसके लिए
राइट. नाउ द court has decided that the entire amount has to go to third party.
Right.
So this is the genesis of the.
This is
the genesis. Whosoever comes to the court, right, his right, title, interest, possession, and claim of compensation will be decided. Who are those persons in whose favor it has been awarded?
Correct.
Now the awardees are before this court.
Well. So now question is, kindly see section 8 and then schedule. एडवोलरम लगेगा वो देखा जाए. सेक्शन 8 ही है.
आपका एग्जाम मेरे पास है.
अच्छा सॉरी सेक्शन 8 देखा जाए. हाँ अपील का यही है. सेक्शन 7 है सूट्स पर. सेक्शन 8 फी ऑन मेमोरेंडम ऑफ अपील अगेंस्ट ऑर्डर रिलेटिंग टू कॉम्पनसेशन. the amount of fee payable under this Act on a memorandum of appeal against an order relating to compensation under any act for the time being in force for the acquisition of land for public purpose shall be computed according to difference between the amount awarded and the amount claimed by the applicant. ये बोला? Now, for me, the amount awarded and what I am claiming, there is no difference.
No. The third party can file a suit claiming the entire award.
Yes,
Yes.
it
So
claimed.
your awarded amount has come down to zero.
Yes, my amount has come to, which is the original award. Then,
Now both of you are fighting.
what I say, which is the award first? 3G इसलिए पढ़ने बोल रहे हैं.
Well, merely because an award has been quantified.
No. Please see what is an award. मतलब original award is 3G. 3G एक बार देखिए ना. 3G एक बार देखिए. एक बार हम धीरे धीरे पढ़. 3G. Determination of amount payable as compensation. यही decide होगा. Where any land is acquired under this Act, there shall be paid an amount which shall be determined by an order of the competent authority. Minus 2. Where the right of user or any right in the nature of an easement on any land is acquired under this Act, there shall be paid an amount to the owner and any other person whose right of enjoyment in that land has been affected in any manner whatsoever by reason of such acquisition, an amount calculated at 10% of the amount determined under subsection 1 for that land. Now, 3. Before proceeding to determine the amount under subsection 1 or subsection 2, the competent authority shall give a public notice published in the local newspapers, one of which will be in a vernacular language, inviting claims from all persons interested in the land to be acquired. Then 4. Such notice shall state to the particulars of the land and shall require all persons interested in such land to appear in person or by an agent or by legal practitioner referred to in subsection 2 of section 3C before the competent authority at the time and place, and to state the nature of their respective interest in such land. This is hearing alone. Then now 5 is very important. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the party, the amount shall, on an application by either of the parties, be determined by arbitrator to be appointed. ये arbitrator होगा. So award is declared here. Determination
Under section 3G5.
3G4.
3G5.
3G. Yes, 3G5, right. 3G5.
6 people.
Well, then, subject to the provisions of this Act, the provisions of the Arbitration Conciliation Act shall apply to
You
every
see, matter is very clear, as I can see. If a party to the award has to challenge the award, then he will be guided by Arbitration and Conciliation Act.
Yes.
But if a third party comes and says that this award has been wrongly prepared, then it requires full-fledged arbitration.
Yes.
And therefore,
Absolutely yes.
and therefore, when that reference is made, it's a regular suit. It is as good as a regular suit.
Yes.
Because right of third party is being determined.
Yes.
And here is a case where third party has claimed the amount. The learned trial court has awarded the entire amount in favor of third party. So you pay at 12,000 rupees.
So, the award.
You pay. It is not a challenge to the award.
Kindly decide this. I will pay.
I will decide.
Decide.
कौन सा judgment आप बोल रहे हो?
हम दे. So मेरा argument
It is the award technically is not under challenge. What is under challenge is the entitlement under the award. A third party is claiming we cannot challenge it under
so
arbitration. and
entitlement and therefore it is a declaration then.
No, it is not a declaration.
It is
It is an adjudication
So what
of right
happened-
title
what-
and not just a declaration. It's a if you say that the award is null and void, it is a declaration. You don't say that. You say that this award has been rightly prepared in my
मतलब
name
kindly-
and wrongly decreed in favor of third party.
अब एक बार काइंडली फिर से देखिए प्रोविजन जो हम सेक्शन 8 का पढ़े थे, सेक्शन 8 में कहा था यही कि अगर मतलब इफ वी गो बाय सेक्शन 8 लॉर्ड से मेरी साइड वाला अच्छा रहेगा, ये कहता है फी ऑन मेमोरेंडम ऑफ अपील। वो अपील किसकी बात कर रहा है? अब हम आते हैं, अगर बोलिएगा लैंड एक्विजिशन एक्ट में, तो वहां पर प्रिंसिपल्स अलग है। एक बार अगर मेरे साथ देखना चाहेंगे लैंड एक्विजिशन एक्ट, तो एक बार मतलब जस्ट फॉर
नहीं, हम लैंड एक्विजिशन एक्ट से कंपेयर करने की जरूरत
आप तो
नहीं।
देखिए हैं कई बार, वहां सेक्शन 18 है, देयर इज अ डिफरेंस। अवार्ड यहाँ बना है, वहाँ अवार्ड नहीं बनता है, अवार्ड से पहले रेफरेंस होता है, और यहाँ अंतर यही है कि यहाँ अवार्ड माइनस बन गया, डिटर्मिनेशन अमाउंट का हो गया। नाउ दैट वेरी अमाउंट इज बीइंग डिक्लेयर्ड टू बी नॉट टू बी पेड टू मी, rather it is being declared to be paid to somebody else, and that somebody else is now private respondent। हम तो सूट फाइल नहीं किए, सूट तो फाइल किए विदाउट
तो
पे।
हारिए चाहे जीतिए, जब अपील फाइल करिएगा तो सूट से ही चलेगा ना।
अब एक चीज वाला एक चीज देख लीजिए हजूर, एक जजमेंट एग्जैक्टली इसी पॉइंट पे है, इसी तरह की बात उठी मद्रास हाईकोर्ट के सामने, एग्जैक्टली यही बात उठी।
That's fine.
अब पढ़ पूरा reading. The appeal is posted for maintainability. The appellant challenges the determination made by the Principal District Judge so-and-so in LAOP number 241 of 2019. The said proceeding arose out of a reference made to District Court under 3H of the National Highways Act. Section 3A and 3J of the National Highways Act provide for a scheme for acquisition of land for the purpose of the national highway, while section 3A, B, C, 3D, 3E, 3F deal with procedure for acquisition such as 3G, provide for a separate machinery for determination of the compensation paid. Subsection 6 of section 3G makes the provisions of Arbitration Conciliation Act applicable to proceedings in determination of compensation under 3G of the Act. 3H of the Act provides for deposit and payment of the amount. Subsection 3 of 3H empowers the authority to decide as to whom of the several persons who make the claim is entitled to compensation. Subsection 4 enables the authority to make a reference to the principal civil court of original jurisdiction to resolve the dispute as to the entitlement of compensation. In the case on hand, the dispute as to entitlement of compensation was referred to civil court, namely the Principal District Court, Velupuram, by the competent authority, and the Principal District Court, Velupuram, has passed an order on 1/4/24 determining the issue that was referred to it. Aggrieved, the appellant has come up before this appeal. The registry has initially raised an objection as to the maintainability of the appeal, since the provisions of National Highways Act did not provide for an appeal against the orders passed by Principal Civil Court of original jurisdiction in a reference made under subsection 4 of section 3H of the National Highways Act. The registry, however, accepted the explanation offered by the council on the maintainability of the appeal, since an order passed by Principal Civil Court of original jurisdiction is an order passed by civil court determining a civil right and would be a decree within section 2(2) of the Code of Civil Procedure, and hence appealable under section 96 of the Code of Civil Procedure. The history, however, instead on appellate of ad valorem fee on the total amount of compensation determined by competent authority, hence this appeal is listed before a decision on the question of court fee. We have heard Mr. So-and-so. Mr. So-and-so, learned counsel for the appellant would contain that a proceeding under 3H is not a proceeding leading to determination of compensation. The quantum of compensation is never in dispute. It is only the right to receive compensation that was in dispute. The order of the civil court made in a reference under subsection 4 of section 3H of National Highway Act cannot be treated as an award equivalent to an award passed in reference under section 18 of the Land Acquisition Act. Since it is only an order determining right to receive compensation, the same cannot be treated as an appeal against an order determining compensation requiring the appellant to pay ad valorem court fee. According to the learned counsel for appellant, according to the learned counsel for the appellant, the appropriate section that would be applicable to section E is section 50 of the Tamil Nadu Court Fees Act, Suit Valuation Act. Section 50 of the Tamil Nadu Court Fees and Suit Valuation reads as
दूसरा प्रोविजन
हम आप
स्टेट का
हम
प्रोविजन
नहीं वो देख लीजिए हम देखते हैं क्या है उसको देख लीजिए हमारे यहाँ का प्रोविजन हमको नहीं बोल रहा है देने के लिए यहाँ पे सिर्फ एग्जैक्टली वही था सेक्शन 25 जो कोर्ट बोला देना पड़ेगा हम वहाँ यहाँ देने के लिए तैयार हैं सेक्शन 25 में वही है जो यहाँ पे हमारा आर्टिकल 13 है देने के लिए तैयार भी हो जाएंगे बुजुर्ग बोलिए यहाँ सेक्शन 25 में बोला देने सूट फॉर डिक्लेरेशन ये थर्ड पेज में देखा जाए ये वाला जो रूल्स है ये रूल एक बार देखिए इस रूल में थर्ड पेज बोला सेक्शन 50 में नहीं दे सेक्शन 50 का नहीं देना सूट फॉर डिक्लेरेशन वाला देना हम भी यही कह रहे हैं कि सूट फॉर डिक्लेरेशन
वो तमिलनाडु के जज में बोल देते हैं कि इट इज अ सूट इट टेक्स पार्ट ऑफ द कैरेक्टर ऑफ द सूट
वो तो बोल रहा है कि चूंकि 2(2) के डेफिनेशन में आ रहा है वहीं का उसके बाद कहता है कि सेक्शन 50 का पैसा नहीं देना पड़ेगा रादर सेक्शन 25 का पैसा देना पड़ेगा क्योंकि 1000 रुपया वहां पे यही
25
हाँ ये देखिए ना एक बार इसका 25 देख लीजिए मद्रास वाला एक
झारखंड वाला भी तो पैरेलल लिखा है 25 का
दिखा देंगे पहले ये तो देख लीजिए
हमको मद्रास बाद में देखेंगे पहले झारखंड
पहले ये तो देख लीजिए
पुराना दूसरा एक्ट बाद में देखेंगे
जी।
पहले अपना एक्ट देखेंगे
हम अपना है
अपना एक्ट में लिखा है ये सेक्शन 25 क्या है
ये ठीक आर्टिकल 13 देखिए इससे इसलिए पूछ रहे थे किसको चूज करिएगा हम जवाब स्ट्रेट नहीं दे रहे अगर वो अवार्ड नहीं है तो डिक्लेरेटरी सूट है आर्टिकल 13 का 3 देख लीजिए
चूज आपको करना है ना आपको थोड़ी करना है
ठीक बात
यस
13 का 3 मेमोरेंडम ऑफ अपील हम फाइल करेंगे इस पर
to obtain a declaratory decree
ये है 13 का लेफ्ट वाला पढ़िए लेफ्ट वाला पढ़िए प्लेट और मेमोरेंडम ऑफ अपील इन ईच ऑफ द फॉलोइंग सूट्स तो उसके बाद 3 पढ़े जो
पैरेलल कहां है
एडवर्ट देखा
ये आप कौन सा पैरेलल टू रूल 25 दिखा रहे थे ना
नहीं, यही है 13 है
ये और ये तो सेम नहीं है
वही उसका 25 तक पर देखिए सॉरी बोलो इफ आई एम रॉन्ग वहां सेक्शन 50 में क्लेम कर रहा था लॉयर तो कोर्ट ने कहा नहीं नहीं सेक्शन 50 नहीं चलेगा इसमें सेक्शन 50 में एक शेड्यूल है जो कोर्ट किया कोर्ट लास्ट पेज सेक्शन
देखिए आप आपकी बात हमको समझ नहीं आ रही, बिना समझे तो अलाउ नहीं करेंगे।
नहीं नहीं, हम बोल रहे हैं ऐसा,
आप जो बहस कर रहे हैं हमको समझ नहीं आ रहा,
मतलब हमारा
हमको एकदम समझ नहीं आ रहा
हम
है।
ये कह रहे हैं इस केस में,
और 4:30 बजे के बाद माइक स्विच ऑफ।
तो इसको दूसरे दिन सुनिए और तैयारी कर लें। हम चाहते हैं कि आपके हाथ से अच्छा जजमेंट लिखा जाए।
हर जजमेंट आपके फेवर में हो तभी।
नहीं नहीं, हम कहाँ बोलते हैं, देखिए ही बोलती है तब फिर लड़ाई वाला बात। आप ऐसा क्यों चाह रही हैं कि हम,
देखिए हमारा ये कहना है, जस्ट मोमेंट, मेरा ऐसा सोच है, which I am making it clear, कि जब थर्ड पार्टी इसको क्लेम कर रहा है ना, वो बोल रहा है कि अवार्ड आपके नाम से गलत प्रिपेयर हो गया है, अवार्ड इनके नाम से प्रिपेयर होना, so he is claiming the entire awarded amount,
हाँ
which has been set aside. Now you are claiming the entire awarded amount in appeal.
माइनस हम उसको ऐसे एनोलॉजी पे फैक्ट पे मत चलिए, लॉ पे देख के चला जाए। मेरा यही कहना है।
रिलीफ क्या है? उन्होंने क्या रिलीफ किया?
मतलब मेरा कहना है कि अवार्ड एक डिक्लेयर जब हुआ मेरे फेवर में, तो उन्होंने एक डिक्लेरेशन ले लिया अपने फेवर में। नाउ आई हैव कम हियर टू,
ऐसा नहीं है, सिर्फ डिक्लेरेशन अवार्ड जब उन्होंने, भाई व्हाट इज द कॉन्सिक्वेंस?
नेचुरली टाइटल तो डिसाइडेड ना होगा, कर दिए।
If you go and seek a declaration that this is my property, full stop, the moment you pray for recovery of possession, उसी तरह से if you simply go and get file a suit that this award is bad in law,
तब
that is a
एक
declaration.
क्वेश्चन हम आपसे करेंगे यहाँ, मेरा दिमाग में अटक रहा है जो, मतलब एक चीज सुना है, एक चीज सुना है, अगर ये डिक्लेरेशन यहाँ से हमको मिलेगा, एग्जीक्यूट कहाँ होगा ये? सिविल कोर्ट में? नो, क्योंकि अवार्ड ऑलरेडी 3G में बना हुआ है, यही अंतर देखना होगा।
एग्जीक्यूशन भी वही होगा,
कहाँ?
सिविल कोर्ट
नहीं होगा,
होगा,
यही 3G का तो ये डिफरेंस है ना।
इसलिए वहाँ पर एग्जीक्यूशन होगा। The reason being there could be n number of objection even in the executive court.
What I say,
Any third party can still file objection in the executive.
अगर ये मान लो, I will learn, I will still know every day we are learning, but my contention is that 3G is the stage on which determination of compensation takes place and it is an award prepared. Now objections have come up, it cannot be equated with section 18 reference. Section 18 का reference होता है लैंड एक्विजिशन एक्ट में, वहाँ पे बिना अवार्ड प्रिपेयर हुए पूरा का पूरा मैटर रेफर होता है और वहाँ पे टाइटल डिसाइड होती है। यहाँ पे थोड़ा नेचर डिफरेंट है। Therefore मतलब my contention is कि सेक्शन 25 जो था मद्रास का एक्ट का, वही यहाँ पे है। हम लोग और तैयारी करते हैं और if lordship,
It is hereby ordered that the compensation amount of such and such in the account should be deposited in the account of the third party. This is the judgment.
कौन अंदर वाला?
नहीं यही वाला judgment.
इसमें देखिए ना जो बोल
He
रहे
is
हैं,
not, you see, the third party did not simply claim a declaration. He also claimed the awarded amount.
मतलब एक
And that is why an order was passed to give the compensation amount to the third party.
compensation with what? सेक्शन 25 का जो हमारे यहाँ आर्टिकल 13 में है, मतलब एक पारा 7 एक बार देखिए, पारा 7 एक बार देखिए इस जजमेंट का। पारा 7 कहता है, नो डाउट ऑन ए प्लेन रीडिंग ऑफ सेक्शन 50 द सबमिशन ऑफ लर्नेड काउंसिल फॉर द अपीलेंट वेरी अट्रैक्टिव, बट if the nature of the order passed by principal court of original jurisdiction in a reference made under subsection 4 of section 3H of National Highway Act is looked at, it is essentially a declaration of a right to compensation which will fall under section 25. इसलिए हम बोले कि section 25 and declaration of right यहाँ पे आ रहा है। पारा 7 is the catch clause decision of the court and ratio, ठीक है, दूसरा कोर्ट का है that is having a persuasive value, उससे ज़्यादा नहीं। So if lordship holds it कि no it is not declaration, then ad valorem कहाँ लगेगा वो भी देखा जाए। इनका शेड्यूल क्या कहता है देख लिया जाए। प्लस शेड्यूल देखिए एक बार, हम आज क्लोजे करते हैं, बेटर होगा।
हम सुनेंगे इसको आज, क्योंकि सुनेंगे तो फिर लिखाएंगे।
ठीक है, ठीक है। देखते हैं हम और थोड़ा थोड़ा वेंचर लगा, हम तो प्रयास ही कर रहे हैं कि कहीं हो सकता है, हमको अट नहीं रहा है, इसलिए हमको लग रहा है कि नहीं ये इसमें लगना नहीं चाहिए नेशनल हाईवे वाले में।
कितना देर में तो बस डिसाइड कर दें।
हजूर ये हम खाते क्लोज कर रहे थे, हमको कुछ नहीं।
क्लोज क्या करना है?
हजूर यहाँ बोले एक बात, अब लास्ट में टाइम ओवर हो गया कि यहाँ पे होता क्या है कि मान लो लॉयर लोग थोड़ा परसुएसिव कम, हमको लगता है थोड़ा परसुएट नहीं करते हैं लंबा। अब हजूर को ज़्यादा मेहनत करना ही पड़ता। अब अगर आप ही कहिए कि नहीं आप ज़्यादा कंफ्यूज करते हैं, ज़्यादा मेहनत करना पड़ता है तो बट बोले आई से कि समटाइम्स दिस हैपेंस बिकॉज मतलब ये चीज़ क्लियर नहीं है। हाँ पीपल हैव बीन पेइंग इट, ये देखना
नहीं people have been paying it, इस ground पे कोई order थोड़ी हो जाएगा।
दैट इज ट्राई माय बेस्ट।
People have been paying it, ground पे order नहीं होगा।
ऑब्वियसली मतलब आई विल ट्राई माय बेस्ट। लेकिन यहाँ पे ना देखिए एड वलोरम कोर्ट फीस का जो प्रोविजन सेक्शन 8 का प्रोविजन और ये जो आर्टिकल 30 मतलब आइटम 13 का है, थोड़ा सा क्लैरिटी का अभाव है एकदम, और लोग कैजुअली देते रहे हैं। ये बात है, कोई प्रोनाउंसमेंट है नहीं। एक जस्टिस इकबाल का हमको मिला बहुत पुराना, बट इट इज ऑल्सो नॉट दैट वेरी क्लियर। वो लैंड एक्विजिशन एक्ट से
अब
रिलेटेड
एक तो क्लियर ऑर्डर करके 2-4 महीने के लिए एडजर्न कर देंगे, दोनों पार्टी में जिसको मन हो अपने चले जाएगा सुप्रीम कोर्ट।
हाँ, नहीं।
जब डिसाइड हो जाएगा उसके बाद तो सुप्रीम डिसाइड करेंगे, उसमें क्या है?
नहीं ऐसा क्या है कि
ठीक है, नहीं दोनों पार्टी को मौका मिलना
हाँ होना चाहिए दोनों।
because it's a matter of you know
आई वाज थिंकिंग
What is the matter है?
स्टेट विल
अब
आल्सो
स्टेट ने तो क्या एग्जेम्पशन का कॉम्प्रोमाइज
We assist करते
तो कुछ कर नहीं सकते, स्टेट को तो इम्प्रूव नहीं कर पाएंगे।
उन लोग भी असिस्ट करते तो हमको एक दो जजमेंट खोज के लाते,
हम ही करेंगे रिसर्च, इसीलिए
हमारे देर नाउ
उसी
प्लस
को करना पड़ेगा। सब होमवर्क हम लोग को दे दीजिए पहले।
हम भी बड़ा खोजने की कोशिश किए, लेकिन है ना बहुत केस रहता है।
स्टेट जो है ना ऐसे कॉपी पेस्ट करके कॉन्ट्रैक्ट मत करिए।
थोड़ा assistance चाहिए तो।
अगर हम एक चीज ये लिख देंगे that state has not opposed,
No, we are.
तो how we are opposing? आप तो लिखिए exemption करके
Next
कैसे?
will
कोर्ट में थोड़ा अच्छा जजमेंट है, लीगल प्रिंसिपल पे आपको भी असिस्ट करना चाहिए, ऐसे थोड़े स्टेट
ऐसी बात नहीं है, सिविल का कोड बहुत बढ़िया चलता है, आप कभी कभी आते हैं।
नहीं हुजूर स्टेट को भी असिस्ट कर, हुजूर बोले
सब लोग बैठे
आप बहुत मेहनत करती
नहीं,
हैं,
मेहनत
ये हमको खबर मिलता है। आपके मेहनत से जजमेंट हो रहा है, बाकी लोग मेहनत नहीं कर रहे हैं, हम एज ए सीनियर बोलेंगे।
ऐसी बात नहीं है, कुछ नए नए लड़के हैं, सीनियर को अच्छा से असिस्ट करते हैं।
यस
बहुत बढ़िया, अच्छा लगता है हमको सुनने में, मन भी लगता है।
नहीं स्टेट वाला फिर आप स्किप करें, स्टेट का मिल रहा है कि नहीं? स्टेट इज नॉट।
हाँ तो स्टेट इन सिविल लिटिगेशन इज ऑन द सेम फुटिंग, उसको कोई रीट में जैसा लिबर्टी नहीं मिल सकता ना,
स्टेट का
फ्री हैंड नहीं मिलता स्टेट को यहाँ पर। अगर स्टेट ने नहीं सजेस्ट किया है तो नहीं किया,
बट दे शुड असिस्ट बस।
इसको क्या करना है?
आई आप एज पर कन्वीनियंस तो 4 बजे होता है सुनवाई ऑर्डर से, किसी दिन 4 बजे रहेगा जब हम और वर्क करते हैं थोड़ा सा।
The matter hearing on the interlocutory application has remained inconclusive. Hold this case for further hearing after tomorrow, Saturday.
ठीक है
यही सुनेंगे बस, एक मात्र
कहाँ अच्छा छुट्टी